So tonight we're going to just give an update on where we see the issues going, both in response to the executive orders issued by the administration and the impact they will have on the workforce, plus all the issues. We're going to address some of the other issues surrounding being placed on federal employees being placed on administrative leave, federal employees being offered a severance package, and just general questions about returning to work as well. I'm joined once again tonight by Ayesha Whyte. Ayesha, do you want to say hello? And we're going to get started. What we're going to do tonight is just have just some opening comments. We've received a number of email um, questions. We did ask folks to send in questions by email, so we're going to go through it, as many of those email questions as possible tonight. Uh, and let me just start from the beginning. I've included this in my notes. Just a disclaimer, we are not offering legal advice. This session is for informational purposes only. If you have specific questions that relate to your specific employment issue, you should consult or confer with an employment discrimination attorney. So, Ayesha, how are you?
I am doing well. Thank you so much. So I am,
Okay.
you ready for me, David?
Yes, I am. Go right ahead.
All righty. So I'm Ayesha White. I'm an employment attorney and I've been one for a little over 20 years. I've had the opportunity to work in the government as well as mostly in the private sector. So as David said, tonight we are going to go through some questions because we know that there's a lot of trepidation and misinformation going around about return to work and the buyouts, if you can call them that. Now, I will say that we got a whole host of questions. We will go through them all, but there are some that we cannot answer because this is such a novel situation. This is something that has not happened in past. And so what we can answer is what has been the law up until this last inauguration. And no laws have actually changed, right? We've had some executive orders. But one of the things that I think that you should think about and look at as you are reviewing this webinar and reviewing what you want to do next with your job is to know that the person right now making decisions is a person who is a convicted felon of 34 felonies, and he has had to serve no jail time. Now, if this would have been last year, that wouldn't have been heard of legally, but that is where we are right now, right? These are some unprecedented waters. We have someone who has filed bankruptcy multiple times, who has said multiple things in the media that are not true, who is known for reneging on agreements that he has with his own contractors, etc. Those are all things that you should consider when you are considering resigning based on the word of someone. The other thing that I will say is that what you have received is a mass memo. You have not received a severance agreement. In every severance agreement, it will say that the agreement that has been made is within the four walls of that document. So what is being asked of you currently is for you, without seeing any contract whatsoever, to say that I resign, and then hope that what has been promised to you is in the four corners of that document. Not only are you being asked to believe that it's going to be in the four corners of that document, you are being asked to believe that even if it is within the four corners of a document, that the person who is giving that to you, which is ultimately the President of the United States, will follow through with any commitments that he has made to you. And you have to ask yourself, is this person a person who is known to follow through with their commitments? So I think that's where we need to start this conversation, with kind of some level setting around that. And I'll turn it back over to you, David.
Okay, so when we ended the session last week, one of the issues that I raised was there are a number of organizations that were considering lawsuits against the administration, and we've seen quite a few just develop this week. We sent out a notice midweek just giving an update on a lawsuit. And today I checked CNN, and I understand that the Department of Education, it has issued letters placing on administrative leave employees who attended DEI sessions, not only folks who worked in DEI or DEIA, but even people who attended DEI training sessions. So in terms of the lawsuits that are pending, there are a couple of lawsuits that have been filed. One lawsuit is challenging the information, your information, informational government employees that was provided to the administration by agencies as not complying with the E-Government Act of 2002, which basically says before you gather information and transmit information, you should first verify where this information is being sent and attempt to get the consent of the employee for which you're providing this information. So that lawsuit is pending in the DC, U.S. District Court for DC. There was a stay or a temporary restraining order issued in a separate case challenging an executive order that purported to suspend the payment of all grants. So a temporary restraining order was issued in that case, and it's to be in effect until Monday. But the government has since resume making the grant payments. So that case is now in the process of being litigated with a motion to dismiss filed in that case. And we're monitoring that case because it gives us insight on how the government is going to respond. And one of the challenges being raised in that case is that the the plaintiffs or the people bringing the claim have not actually sued the agency. And that's an important point because the president's executive orders basically are not going to be subjected to review or judicial review by the court. It's going to be very difficult to challenge the executive orders. And what the president has done is he's being advised by the Office of Budget and Management. And then we have directives being issued by the Office of Personnel Management to the agencies. So it's really an issue of who should be sued. And the first question is, in determining who should be sued, you're going to have to challenge, or the challenges are going to have to come against agency actions. And so that's one of the issues that we're waiting on. So some of you are in a holding pattern. You've been placed on administrative leave, but you haven't received any final agency decision. Courts will review final agency decisions and determine whether they comply with the Administrative Procedure Act. I mentioned that last week. That was one of the ways that we were going to see, I suspect that we would see people challenge some of these actions would be under the Administrative Procedure Act, basically saying that the agency had not provided notice or comment or an opportunity for entities to comment before changing the agency policies and agency regulations. So I suspect that most of these agencies are going to have people impacted by DEI, probably on administrative leave, until a decision is made on how they're going to implement this. So once again, the executive order is probably not going to be reviewable in court. We're waiting for agency action in most of these cases. And then from the agency action, you will be able to challenge the agency action either through saying that you were not provided notice or an opportunity to comment before the agency takes on the additional action that it intends to take, or bring some other claim that it's arbitrary and capricious or a violation of some other law. We saw with a lot of the DEI offices that people who ran those offices or were in director positions in those offices had responsibilities for other parts of the EEO process. So to the extent that your agency had a DEIA office and it lumped into that DEI office the processing of EEO complaints or filing of EEO complaints, or for example, I know that one agency actually processes interpreters for its deaf and hard of hearing employees in the DEI offices. So there may be individual legal claims that result from the efforts of these DEIA offices, agency decisions to dismantle the DEIA offices and place the DEIA staff on administrative leave, and then possibly initiate a reduction in force. And just a quick summary, if someone is placed on administrative leave, and we're going to get to the individual questions shortly here, but if someone is placed on administrative leave and then they're subjected to a reduction in force, the agency should offer them the opportunity of being placed into a comparable position, or if that's not available, the agency should offer severance pay. So if the agency attempts to go forward with this reduction in force and does not offer severance pay or does not place the employee in a comparable position, the employee has the right to challenge the reduction in force through the Merit System Protection Board. And if that happens, you're going to have to lawyer up and get prepared to present a case before the MSPB. As I was preparing my notes today, one of the things that I thought about as far as general advice to federal employees is to really just take the time now and try to get prepared. Just do a summary of, for example, if you were going to present your information to an attorney or consult with an attorney, the attorney's basically going to want to know, give me a timeline of what's actually happened. So just take some time to detail your position, your duties, when you started employment, and how you've been impacted by whatever action you want to challenge, whether it's the return to work executive order, or whether it's the DEIA executive order, or if there's some other executive order that will impact your employment. I know that there's a push to reduce the federal workforce, but we do have laws in place. And someone asked the question, well, is anyone doing anything? Are we going to be able to challenge this? The first thing is, yes, folks are looking. There are attorneys in Washington, D.C., and probably all over the country, employment attorneys looking at ways to challenge the executive orders. I know that a number of the labor unions are filing challenges as well. One of the issues for the labor union is, if there's a grievance that needs to be filed, there's a process that's filed. And if the grievance is not resolved, then a claim is filed with the National Labor Relations Board. Well, one of the problems is that the president just removes someone from the National Labor Relations Board, so there's no longer a quorum there. So the question becomes, okay, if your union needs to challenge these issues through the National Labor Relations Board, will that board be able to hear the dispute if there's no quorum? And it won't be able to. So that is another issue that may result in claims ending up in court. The same is true with the MSPB. We had this in the last Trump administration. The administration did not appoint board members, so there was no quorum available to hear appeals when employees filed with the MSPB. Yes, they received an initial decision by an administrative judge, but if they wanted to challenge the initial decision, there was no quorum with the MSPB board to hear those cases. So those are kind of the opening comments on where we are. What we're going to do is go through some of the questions. We've invited folks as well to go ahead and put your questions in the group chat. Ayesha, if you have anything else that you want to say before we get started, just go ahead and chime in. And we're going to kind of tag team this session. So I'm hopeful that if there's something that I'm unable to answer, and I don't want to say that I'm able to answer all the questions, I practice employment law, but this is also an administrative law area, and there are attorneys who practice exclusively in administrative law, and also there are constitutional implications as well. So maybe we may have to bring on a whole panel of lawyers who focus in different areas. So Ayesha, if you have anything else before we get started, just go ahead and let us know.
I think the only thing is we are capped in this Zoom at 1,000 participants, and we have reached that cap. So we can't open it up for anyone else. I see that in the Q&A a lot. It's just reached capacity, but we are recording this in order for people to be able to see it at a later date. That's
Okay,
it.
great. Okay, Kaylin, do you want to help us out with the questions? I think we're going to put them in the group chat. Or if you want to read through the questions, that would be helpful.
Sure, no problem. Some employees are receiving emails from an OPM email address that management confirms as valid, yet public figures claim the administration may not honor its commitment. How should employees interpret this conflicting information?
Okay, and I'm going to answer questions, and Aisha, if you feel like you want to chime in at any point in response to any of the questions, just go right ahead and do that. And then we'll continue and tag team the session. All right, so your guidance on your employment should really come from your agency. And it's very troubling that you're getting information from OPM. I guess there's not anything illegal about OPM providing this information, but the guidance that you rely upon should come from your agency. So any information or guidance that you receive from OPM, I would respond back to your human resources or respond back to your agency to make sure your agency confirms that this is authentic before you begin to respond or attempt to respond to it. I know that you're getting information from OPM, and then you have public figures. I think Representative Tim Kaine, Senator Tim Kaine from Virginia this week commenting on whether people should consider the separation package. The problem is this is highly unusual. This is the most important. I mean, your job is the most important, probably the most important aspect of your life outside of your family. Your income is totally dependent upon it, and it's just highly unusual to have um, any conflicting information coming from the government that concerns your employment, and that's very troubling. So I would say, one, you want to confirm with your agency that this is authentic whenever you receive any communication from OPM. And the other problem is there should be some written documentation if an employment separation agreement is being offered before you commit to agreeing to accept anything. You need to see what the details are. We're going to have some questions later about, hey, I'm a probationary employee. If the government's going to downsize, you know, isn't it true or would not be in a better position to consider accepting 8 months of severance when it's not sure if I'm going to be able to survive? Well, it could be, but I'm not so sure that you an offer from the government to a probationary employee. I'm not sure that that's going to be offered. It's not. We just don't have enough information. But you want to get that confirmed from the agency. The problem is many of these agencies don't even have secretaries or political appointees in place. So we're not getting any guidance from the agency. So I don't know how you can make a decision to end your employment without getting any information or at least a written agreement from the agency on the terms that you're agreeing to. And Ayesha, if you want to comment on that, just let me
I
know.
I do. I think the first thing is we have so many questions. We're going to go extremely rapid fire through some of these questions. I think that's probably going to be really helpful. The question here really has to do with how should you weigh this conflicting information? And I think that you should weigh the conflicting information on what are verifiable sources, right? I think if you have a senator, Tim Kaine, who has been a senator for decades, doing well for the people, saying that, hey, this is troublesome. If you have a union who has already filed suit regarding the return to work because they feel it's illegal, etc., right? I think you should listen to the voices that you believe that are voices of reason. Um, Absolutely, unequivocally, can this go left? I just want to make it clear, this can absolutely go left. If you resign, at this point in time, there is nothing in law that says that your severance agreement or package has to be honored, right? Every government employee is their salary is based on a budget. They're giving you money from a budget that has not been proposed or granted, right? And it's outside of the $25,000, which is normally given in any type of government layoff. So they're going far beyond anything that has already been codified in law. So right now we're at a place in which things are going from a very renegade fashion, right? So I'm going to rapid fire through a few questions here because I think that will be the most helpful. Because some of these questions will not be able to be answered by us, I'm going to go to some of the ones that we got about employment and resignation issues. One of them is, have any high-level officials reviewed or approved the forms that must be signed? We don't know that as of now. We don't know who has seen what. What we do know is they are asking people to resign prior to receiving any type of contractual language at all. So you could, in theory, write resign, send an email that says resign. You have then, in effect, resigned your job, no matter what this document comes back and says to you. So definitely think about that. Another question I have is, if an employee chooses a buyout, do they retain the right to stay until September 30th, or can leadership terminate them earlier? They can absolutely be terminated earlier. Are there any pending lawsuits regarding the executive orders that override OPM guidance? Yes, there are. Currently, the union, the American Federal Union for Government Employees, they have an injunction that they filed for a temporary relief, so people who have special situations do not have to return to work. Also, to counteract some of these executive orders that people think are illegal, which currently go against stated law. Another is, can an employee apply for another government job position during the deferment period? This is a great one. Okay, so the guidance says yes, but the law says no. The law that is currently in place that has been passed says that if you receive a severance from the government, you have to wait 5 years in order to be eligible to be rehired by the government, or you must pay back every dollar that you were given in a severance. That is what the law states. And the law trumps a memo at this point. So we're going to go again. Let's see. Can an employee who opted for a deferred resignation, what options do they have if the payments are not made? Now, that's the tricky one. The options are extremely limited and likely include filing a lawsuit against your government agency or a class action lawsuit. But as we stand here right now, there is no clear legal framework for this because we have never had someone, a president or anyone else, who has tried to do this, to upend the federal government and the federal government workforce, right? It is true that it is possible that the government may not be bound to uphold the promises to give you money under a budget that has not been passed. This is very different than a private sector contract, right? Right now, the intervention is coming from people who are under an employment agreement or a CBA with the union, but we know that tons of managers are not a part of the union, right? So honestly, the oversight body is the place that you would go to first. The problem is all of the oversight committees are also run by the executive branch. So it is a very tricky space to be in. And with that, I'll turn it back over to David. I think I went through maybe 6.
Okay, no, I appreciate that. So, and I'm just going to go through a couple of questions as well. In recent actions include a 70% downsizing of OPM impacting benefits. Why is OPM not enforcing its own policies regarding downsizing, voluntary resignations, and third-party email systems? All right, the issue is even folks at OPM, at least the people who are directing OPM, these people are going to be political appointees or subject to the president. So the issue is you have folks being placed at the head of the agencies as political appointees, people in the Office of Budget and Management, basically political appointees, and the senior people at OPM. We did see someone, I guess, who was a whistleblower, reported what was actually taking place at OPM. There was an acting person in the senior position in the office, but basically just a yes person or a yes man taking directions from political people. And then, so that's the issue with OPM. You have the political process is not, the process is not working as it should. Congress should be a check and balance on the executive branch, but the members of the House of Representatives and the Senate, they're both controlled um, by Republicans. So there's not going to be a challenge coming from Congress. And so the last resort is the court system, which may be the only resort here. And we will see as these lawsuits are filed in the federal district court and then work their ways through the Court of Appeals, the Circuit Court of Appeals, and then finally the Supreme Court. Most of these issues will probably have to be resolved at the Supreme Court. But the agency, not the agency, the administration is basically bombarding um, the system with all of these executive orders. And it's like things are coming from every angle, and people are going to have to file lawsuits. The federal employees have been found flat-footed or caught flat-footed here, and this administration has been planning this for at least maybe a year or so. The people around the president have been planning this for a year. So they are carrying out this plan, and the only hope is to somehow get petitions filed in federal court after there's a final agency decision raising some of the issues. Either these actions violate the Constitution or the Administrative Procedure Act or some other law of regulation that the agency is required to carry out. All right. I think that answers the next question. How is it that the administration appears to be acting outside the law without accountability? It's not acting outside of the law. The president has every right to issue executive orders, but there should be some way to challenge the executive orders if they run afoul of the law. And we're seeing that in the different lawsuits that are being filed. The next question is the elimination of federal employees and positions follows a legal process. How has the administration been allowed to bypass these laws? And if so, is this legal? And this is, once again, there are options available for federal employees if you are subjected to a prohibited personnel practice, which may include, some type of whistleblower activity that you're disciplined or removed, or political activity. There's a whole category of reason or prohibited personnel practices. The process is to file initially a claim with the Office of Special Counsel and then file an appeal at an individual right of action at the MSPB. So there are options available to challenge the actions, but for most of you, you're not in that point yet. I think, this week is going to be telling when we see how many people decide to resign and whether the administration moves forward with plans to drastically reduce the workforce. It's unfortunate, but it looks like if they move forward with these plans, and I haven't seen anything to suggest that anything is going to stop Elon Musk and the plans to drastically reduce the workforce, except a court action. So, and I think the administration is moving in a way so that folks won't be able to do this collectively as a class action, and folks are going to have to either just accept the separation or individually hire lawyers to pursue claims on their behalf. I think that's part of the issue. All right, Ayesha, you want to comment on any of this?
Sure. Well, not anything that you've said already. I think that is the case. I think we are all here because we are in this legal conundrum that has never been done. We have had at least every president up until this point understand and rely on the Constitution when they're making executive orders. That's just not where we are today. I do want to go through a few of the other questions. I will go back to David and say if you have very nuanced questions, then you absolutely should be meeting with an attorney about your nuanced issues. It does say that some federal employees are required to return to work full-time despite medical conditions. Can a person use their accrued leave, sick, or annual to adjust their schedules without retaliation? So I think those are two separate questions. One, can you use your accrued or sick leave? That's definitely something that you work out with your HR person and OPM, right? This kind of retaliation thing is a very separate thing. You should not be subjected to retaliation in any way if you are trying to use your ADA accommodations. And that is what you would be trying to use. If you go to HR, you would be asking them for a reasonable accommodation, right? To be able to utilize some of your sick leave in order to modify your schedule. Okay. We talked about this, employees under master agreements,
Wait, Ayesha, before you move on off that package, move on off that question. I think we had a question, a more detailed question about this ADA issue and just the process that should be followed. And so let me just comment on that before we move on, so we don't have to pick that up again. If you have a medical condition or a disability that requires, for example, that you telework, or that if your doctor certifies, whether it's physical or mental or some other condition, that it serves your medical interest to not be required to come into the office every day, you should follow the process. Most agencies have a reasonable accommodation office, so it doesn't necessarily have to go through your supervisor, but there's a reasonable accommodation office that should be able to provide a reasonable accommodation form, or in some instances, it may be an FMLA form or whatever if you need to take time away. And that should be completed by your doctor and returned to the agency. And then there's a process that's followed. There's an interactive process where the law requires that the agency review the requested accommodation and determine whether it would create a hardship for the agency. In the absence of creating a hardship, and it's going to be very hard to make this case that it creates a hardship if you haven't been in the office for 4 or 5 years and you've received successful performance appraisals. That's the process that's followed. I would encourage you, if you already have an accommodation, just make sure that you comply with whatever requirements that your agency imposes. And if the agency orders you to return to work, despite the fact that you have a reasonable accommodation plan in place, you definitely need to talk to an employment attorney about pursuing a claim against the agency. Or I didn't mean to interrupt you, Ayesha, but go ahead.
No problem at all. I'm going to move on. One of the questions is, if you work under a master agreement, can the administration legally override these agreements? And the answer to that is no, which is why there is a suit in place for injunctive relief. We are going to follow this time and time again. Can they do it, and are they doing it? Is two very different things, right? Are they doing that? They're absolutely doing that. And so what happens now is lawsuits are being filed to determine the legality of that, right? And that is before federal judges. And that is its own quandary, right? Judges are individual. Some judges have been appointed by the person who is making these claims. And if you make a claim against the government, even if it's based on an executive order or something of the like, it's really our tax dollars paying for it. It's not the president of the United States paying for it himself. So there doesn't appear at this time that there is any reason for this not to continue to go forward and this to cause a lot of legal headache, because the president does not have to pay for his legal defense of his decisions alone.
And
So
can I make a comment on that as well, if you're done?
go ahead, David.
No, thanks. What I was going to say, and then we have the equation of Elon Musk. We have to factor in that from his perspective, I think lawsuits are just, part of business. So they factor in, okay, well, we're going to do what we want to do, even if this costs us, X millions of dollars or whatever. And so when you have that, and everything suggests that Elon Musk is a driving force behind, these actions to reduce the federal workforce. And he's done this with some of the companies, that he's taken over. Okay, we're going to get rid of these folks, and basically we will pay on the end of this. We will delay this as long as possible, and hopefully there will be some misstep or favorable decision along the way. And in the end, if we have to pay millions of dollars, then we're perfectly okay with that. Of course, that works in the private sector, but it shouldn't work in the federal government. But it looks like that's how they're approaching this, that we're going to do whatever we want to do until the court stops us. And if we're ordered to pay at the end, then we'll just absorb the loss at the end of end of the litigation, not taking into consideration the impact it's going to have on how the government delivers services to the people of citizens of the United States. Okay, go ahead,
That's
Ayesha.
correct. I think the mantra here is to not ask for permission, but to ask for forgiveness at the end. That is what the government is doing right now. So the next question that I have is that if a federal department or agency is shut down, do labor laws require that full-time career employees be reassigned? It does not. So it does not say that you have to be reassigned to a new agency. I will take the USAID as one. It has been proposed that it may fold into the State Department, or that is what is being touted out as a possibility. That does not mean that everyone at the USAID will get a job at the Department of State. You can have an interagency transfer, right? If that is allowed, if that's given to you, but there is not an automatic, now you have a different job. If your agency shuts down, your department or your federal agency, that includes the workers that are within. Let's see, can a federal employee be fired for making minor changes, such as updating their email signature per recent memos? So I'm going to say this now. It appears that, now, can they be fired legally under current law? No. Is this person who is running things right now doing things necessarily that are under the current law? No, right? So I think I'm going to answer all things like that. The can it's, right? Yes, it can happen. Should it be happening? Is it legal to happen? That answer is no.
Okay.
Yep.
And typically that type of case would end up before the MSPB. We've had a case recently before the MSPB went with a client who basically said to the supervisor, "I'll be happy when there's a new administration in place." And this person gets removed from her position, and the case ends up before the MSPB, and the MSPB administrative judge basically says, this is not a valid basis for removing someone. And I know, with the DEI initiatives, that it's pretty common now for people to add pronouns at the end of their name. And some folks have welcomed that. It looks like some people in the new administration are offended by that. Whether that under normal circumstances would result in someone being terminated, the refusal to remove that, I would probably say no. The chances are that you would not be terminated, but it looks like it could result in termination, depending on the directives coming from the White House. Okay, Ayesha, go right ahead.
Back to me. Okay, great. So I think we talked about their reasonable accommodations, right? I do have a few questions about that. I'm going to let you handle policy language questions and so forth. I think there are a lot of questions on this Q&A. If one does not resign, will they eventually be terminated? We certainly can't answer that, right? They're just some of these questions that we cannot answer. Let's see.
Well, I know that we can't answer this, but let's kind of hash this out a little bit. The person is saying if they do not resign, can they be terminated?
No, they're saying, will they be terminated?
Will they be terminated? Well, I think the administration has made it very clear that they're going to give folks an opportunity to resign. And then it's almost like if you don't accept this resignation, then almost anything can happen. So it's really hard I agree. We can't say, will they be terminated? But I think they're going to definitely go after folks who are probationary employees. I mean, if the goal is to reduce the federal budget by billions of dollars every day between now and September, as some news outlets are reporting, they're going to go after the folks that they can, get rid of without legal challenges first, and then they're going to try to go after other folks as well. We can't say whether you will be terminated or not, but if that actually happens, once again, the agency is going to have to comply with the law as it exists now and justify why they're taking action to remove folks. And obviously they can't do it in a discriminatory way. They can't do it that for political reasons or in any other way that violates your rights. And if that happens, you're going to have to get employment counsel to try to combat your removal or separation.
Okay, I'll jump back in here. Can one lose their job if they served on a diversity committee at an agency that they're no longer employed with, but they're still a federal employee? So the law indicates that you cannot be fired from any job, public or private, for serving on a diversity committee. That is just discrimination, right? So we're going to get to this can and will happen, right? I should start this with, people are fired every day for discriminatory reasons, every single day in the private sector, right? Can it happen? And that's why a number of people sue, right? So now this is just crossing into what appears to be the federal sector, right? So please know that right now it looks like anyone in the federal government can lose their job for any reason. We are at a point that the USDA Inspector General, right, who's worked there for 22 years, was walked out with armed guards. So any and everyone that works for the federal government can be fired at this point, regardless if that's legal or not. And I guess that's the question. Those are the things that we're trying to figure out. Can it happen? Absolutely. Because it is happening, and it is happening to high-level people.
Ayesha, I will add in, I think I mentioned this earlier. I just saw a report on CNN earlier that people at the U.S. Department of Education who attended DEI training sessions, as well as people who were responsible for the DEI programs, at least 50 individuals were placed on administrative leave. I think maybe just yesterday or maybe January 31st. So that would have been Friday. So yes, it appears that they actually went back to see who was trained on DEI, and those folks were on the list as well. So it's possible, and I'm just telling you this just to get prepared. It's possible that even people who went to DEI training or volunteered for DEI events, or of course worked directly with DEI, your name may appear on the list of folks that these agencies want to separate. And for some reason, these agents, at least the administration, seems to be saying that anyone that we perceive as, supportive of DEI initiatives or may not be loyal to this administration, we feel like we can target those folks for removal. So, and I think it goes to your point that we're going to take this action, and then we'll ask for forgiveness later, or see what happens at the end of the case, and see if we need to pay something or repent later. All right.
Exactly. Okay, so I have a question. Does it mean that if someone resigns in that email that they don't have to honor it and they can change their mind? I'm assuming that this means the employee. If I hit resign, that is it. I have resigned my job. I cannot, if I see this contract and I'm like, oh, this is terrible, take that back because you have already resigned your position. Once you say it, it is done. And right now, it does not look like they're accepting any rescissions of resignations. Let's see.
I will add to that. I've litigated that issue before. We represented a client who resigned from his position under pressure from his supervisor, and days later, maybe after going home and talking to his family, he decided that, hey, I've decided that I don't want to resign, and I want to rescind this resignation. And we litigated this issue in court in the District of Columbia, and the court concluded that the employer was under no obligation to accept this rescission of a resignation. So until you have all the information and you can make a conclusive decision, I would definitely encourage you not to resign your position. It may be one of those things that just can't be revoked. uh, Although there's an open question on whether the government is going to fulfill its obligations under the agreements that it's proposing for employees. Okay.
Great. So I am going to move to the next one. Right. I think I have a question here from Melissa, and it says, it may be futile for people with endless to try to fight against people with endless resources, etc. I do always believe in fighting, but I want to tell people that what this is, employment law and civil litigation, these are not things that happen typically in 10 days, 30 days. These are longer lawsuits, right? And so even if you sue, it could go on for a year and a half before there's any big movement. And certainly, right, the administration we're dealing with will try to put in as many roadblocks as possible. Another anonymous attendee is saying that they're in the deposition and discovery phase of an EEO, I'm assuming suit, and they want to know if they should withdraw their case. You should absolutely talk to your lawyer about that. If you are already at the deposition phase of litigation, you're probably really far gone in. One of the other pieces is if you have a private attorney versus is the EEOC helping you with your case? Are they serving as your attorneys? Because that's going to matter whether you can withdraw this case at this stage or not. So I would definitely say talk to your lawyer about your concerns because you definitely have one if you are at the deposition stage.
But I'm a little curious on that question. Is that person inquiring whether they should withdraw the case in light of what's going on with
Yes,
the new administration?
yes,
I mean,
or
because I
they're
assume
concerned about
if they
the
have a case that's in the deposition, the discovery phase now, it's very likely it's because of action that happened years ago. So we're not saying that, walk away from your EEO cases. If you have a valid EEO case, I don't think that there's anything that the administration can do to change the outcome of a valid EEO case. That's going to go through the process at the EEOC and in federal court. So we're not saying I'm not saying that there's no option for you to get justice or you should abandon your EEO, your cases. Yes, if you've been discriminated against by the agency and you have an attorney working with you, or even now, if you face discrimination, you should definitely pursue claims, and there should not be any retaliation against you just because you're pursuing a claim. I don't think that, I mean, if that the agency is going to be foolish enough just to terminate you for no reason. I mean, the agency can always terminate employees for performance or conduct at any point, regardless of whether they have a claim pending or not. But if you're at the litigation part of your case in discovery and you're challenging employment action from years ago, I would say definitely continue the case until I don't think anything the administration has done here should change the course on whether you decide to pursue the case. That should be driven by whether there's been a violation of your rights and the facts in your case. Okay, my apologies. Go ahead.
Okay, so I am going to just circle back on this one because the question was, should I withdraw my case for some fear of DEI retaliation? Again, I'm going to ask you to talk to your attorney because it appears as though you have sued your own agency that you work for right now, right? And there is a belief that Elon Musk or Trump would not want to keep someone who has successfully sued the government. So please speak to your attorney about your individual case and your individual facts.
And if that happens, that's definitely retaliation. If they try to get rid of you because you're suing your employer for discrimination or well, because of or DEI, any DEI initiative, that's definitely a violation of the law. And you should probably, if I'm your attorney, we're going to amend your complaint to add, additional claim if action is taken against you because of this new administration.
Okay, so in light of time, we're gonna go back to the rapid fire piece. Let's see. I'm fired for following the law. How much could I sue for? One. Okay, so depending on your particular situation and where you live, right? Because there are lawsuits that can be filed in federal court, and then you also have some particular states' rights. So, Bell, it really depends on why it is that you're fired. Like different people have different federal lawsuits, right? It depends on if it's a pay equity suit, if it's fired without cause, if it's based on discrimination. Thus, it is hard to say what it is that you would be entitled to. It depends on the type of suit that you file.
Okay, can I comment on that as well?
Sure, David.
Okay, so the for federal employees, there's a cap for federal employees for claims. First, if you're terminated and you lose wages, you're always entitled to any amount of wages that you've lost. So there's no cap on that. If you were terminated, or you've lost 300 or 400 or $500,000, then yes, you can always recover your lost wages. We had a case recently against the FBI, and our client won, and he was awarded back pay for 5 or 6 years. But then, so there's a cap for compensatory damages, and that would be $300,000. So there's no cap on what you've lost in wages. There's no cap on what you've had to pay for medical expenses or out-of-pocket expenses. But there is a cap for compensatory damages. Depending on your claim, if you have a claim under the Age Discrimination and Employment Act, there are liquidated damages, twice the amount of damages available to you. So I assume all of our folks are federal employees. So there is a cap. Your claims would be under the federal employment discrimination statutes, whether it's equal pay or Title VII of the Civil Rights Act or the Rehabilitation Act if there's a disability discrimination claim. So just to add some additional information there. Okay.
All righty. Do you want me to start up or do you want to?
Yeah, go right ahead.
Okay. Let's see. Placed on priority list. So the question is if employees are blackballed once they're placed on, it looks like a DEI list of people who had done DEI jobs before. Everyone has the exact same employment rights, right? You have the right to be in a workplace that is free of discrimination, that is free of hostility, and that a place that which you are not fired unjustly. When you are in the federal government, you have a few more rights to your job if you have passed the probationary period than if you were in the private sector, where there is just not that type of protection. So we want to talk about this. Everyone has the same rights, right? The question is, these are things that are being done that under current law appear to be in complete contravention of current law, right? There is someone who wants us to know that it's not return to work, it's return to the office because they have always worked from home. That is correct. I agree with that. Will these issues be ripe for a class action suit? It is very difficult to tell right now. It depends on how many people are subjected to the same type of behavior. And right now, we don't know how many people that will be.
Okay, and can I just comment there? And plus, we're dealing with different agencies, so we're going to get different explanations from all these different agency heads on why they're taking this particular action. Even though they're getting a directive from the Office of Personnel Management, it's unlikely that the folks at the Department of Defense are going to have the same explanation as the people at the Department of Agriculture or Education. So to go forward with a class action, there needs to be common, issues of fact, common issues of law. And I think some of the agencies are still trying to decide what are they going to do with these folks that they've placed on administrative leave? How are they going to justify or find a way to subject these folks to a reduction in force as the directive that they're receiving from the White House. And so it's going to be very difficult to have a class action that says we have 500,000 people who were all, terminated because of this new administration, because you're going to get different explanations from all these different agencies. And I just don't think that's going to be manageable across the board. We have, I think, 2 million federal employees. I don't, if they're going to cut the workforce by, 10 or 20%, that's, 200,000 to 400,000 employees who could possibly lose their job across, I don't know how many federal agencies. Okay, so that's the comment.
Okay, so we have a anonymous attendee who is saying if we're experienced with Schedule A hiring authority for people with disabilities, they have a couple of questions. I am, and I'm sure David is as well, but that does sound like something that you may want to have a consultation for. That just sounds like an individual situation that may be layered and nuanced. The, the next one is they want to double check to make sure they understood. So people attending DEIA trainings are of risk of being put on administrative leave. It appears so because people have been placed on administrative leave for attending these types of trainings in past. Is that legal in the way that we know it as of today? No. Is that happening? Yes. Did you say that if there's a rift at your agency, that the agency must attempt to find you a comparable job or role? Absolutely not. They do not have to try to do that. And if the agency closes, they do not have to do that either. And that's just normally, right? But you are eligible to do something called an interagency transfer, but it is not guaranteed. The role has to be open and you have to be selected for the role. Let's see. Someone said that there's no space for employees. I have no idea where they're going to be putting people since some of the GSA buildings have been sold. Let's see. Oh, this is a question I think maybe you would know, David. Um, if an employee is subjected to their new reclassification, right? And I guess that's the one that gives you less job protections, how they've been reclassified. Is that something that can be taken before the MSPB?
Okay, so I think this person is probably referring to Schedule F employees. So in the past, in the prior Trump administration, there was a classification of Schedule F employees. The goal was basically to create a class of almost at-will employees, people who are working on policy issues, and these folks could be brought in and terminated without the protections provided to career employees. President Biden rescinded, it's one of the first things that he did is rescinded the Schedule F employees. And so now there's an effort to bring back Schedule F employees. So if you are in a Schedule F position, if there's a directive order, if there is a executive order, or you're placed in a Schedule F position, you will not have the same level of protection as you would as a career employee. So yes, I don't think MSPB is going to be an option for you if you're placed in a schedule, if you're moved into a Schedule F position and there's action taken to remove you. So you're going to have to talk to or confer with an employment attorney and actually someone has to sit down and read through the regulations as well on that particular point. And all right, any other comments?
So does an employee with less than 1 year of service have any rights? If you are still in your probationary period, your rights to your job have not affixed in the same way as other federal employees. So right now you are still at the place where you're kind of more of an at-will employee and you can be fired for any reason. David, do you have anything else on that?
Yeah, you can be fired for any reason, but the agency still can't discriminate against you. It can't fire you for any violation of your protected class, race, sex, gender. So Title VII still applies even if you are if you are in your period of probation. But It's just the protections for career employees does not apply. But we've had many cases where, I don't say many cases, but we've had some cases where people were terminated in their period of probation, and they pursued EEO cases, and they were successful with EEO cases. So that's still an option available to you.
So the next question is, can you please confirm that Elon Musk and his Dodge employees have taken over aspects of the executive branch to include OPM? I don't know if they have or not. Like I can't confirm. I can definitely say what I have read, which is they have been given access to a lot of systems, and people have been trying to stop them from gaining access to systems, like at the AID, where they tried to stop them physically almost from getting things. Right now, it is definitely questionable if that is legal because, to my knowledge, Mr. Musk and some of his workers do not have the appropriate security clearance for those things. There's nothing that has been said that he has been given a top secret security clearance, which is, provided to those who get to see these types of things that are in OPM, GSA, and the like. But I think we're going to get into this normal, is this legal? And most of it, we're just going to say, based on the laws as they were articulated yesterday, absolutely not. There are not any buzzwords or arguments that people should include in their reasonable accommodation request. What I will say is or a reasonable accommodation request as they are challenging return to work in office. Now, I think that in terms of if you are requesting a reasonable accommodation, please make sure you need one. Because what happens is if you request one, or tons of people request them that don't actually need them, it is actually going to preclude those who need them from getting them, right? Just as David was saying earlier, the agency has to prove that it will be an undue hardship. Say 90% of the people who are asked to return to office say that they cannot, and they are requesting a reasonable accommodation. The agency then could say, like, this is this is a hardship, right? Because 90% of the people who we need to have back are saying that they can't be back. Now, if you actually do have a disability and you actually do need a reasonable accommodation, please do so. But if you do not, please think about those who actually do need them and be considerate of that. Let's see. At Department of Homeland Security, they're telling employees that there will be 2 people to a cubicle. There is no space for employees. What are we to do? How is this legal? It is absolutely legal to have 2 people in a cubicle. I worked at the U.S. Department of Transportation, 2 people in a cubicle. So that is in fact legal. So I don't think you can ride against that one unless, David, you know something I don't.
No, no,
Okay, because I was definitely
unless your doctor says you need you need a private cubicle. I don't think that there's any protection for something like that. So.
okay. Let's see. So it says, are you subject to these adverse actions if you were in a signed settlement with your agency prior to January 20? So I think it depends on what it is that you signed as a settlement with your agency. That's another nuanced issue based on the contract that you filed, right? So definitely consult with an attorney on that one.
And I'm going to say for anybody who has a contract, your contract is going to govern. It should trump any, even an executive order, unless, I mean, the issue is going to be decided by a judge, but basically, if you have a contract, I don't see how an executive order would void out the contract.
Okay, some of the questions I'm going to try to answer to the best of my ability, but I am not necessarily understanding the questions. It says, if you meet the eligibility requirements, I'm not sure the requirements of what, maybe the buyout offer, and accept an offer of this nature, I'm assuming is the buyout, will you be forfeiting your retirement benefits. So depending on where you are in your retirement journey, are you already retirement eligible age, right? Have you already done your 25 to 30 years in service? Those are all individualized questions, right? But if you've been working with the agency for 5 years and leave, yes, you are forfeiting some of the things that have been placed in your retirement. So those are individual as well.
But, and I would also add, I don't think we have enough information from OPM or from the agencies to make that type of decision. I mean, a lot of people may be eligible for retirement, but someone from the government needs to say, what is going to be the impact on me? And that's how it's normally done. If I accept this severance offer, if I'm eligible for retirement, what benefits will be impacted by that? And I can't advise anybody to make that type of decision until you get an answer to that question. And it seems like part of the plan is to deliberately not provide an answer to people for questions such as this, anything that may be gray, so that they can later argue, well, we never agreed to that. So that's not we're not obligated to provide that to you.
All righty. Benjamin says, I was placed on paid administrative leave by my agency and remain in that status. OPM directed the agency to deactivate my agency accounts for myself and my fellow DEIA employees, so we don't have access to any of our personnel records or agency systems. Despite my paid administrative leave notice stating that my placement into this as my official duty status isn't due to any performance, could this be considered a tangible adverse employment action? You not having access to your accounts is not a tangible adverse employment action unless you are required to do work as you're on this administrative leave. You not having access to a system that you are not expected to work on is not an adverse employment action. You can get your personnel records through requests that don't have to be through your agency system.
And you are on paid administrative leave, so
Yeah.
it's not an adverse action yet.
Mhm.
But it sounds like it may be a case coming soon.
Right.
So,
Is a probationary employee limited? Okay. Probationary periods are told to you in your offer letter. Some agencies do not utilize the probationary period, right? There is some, I know for attorneys that come in, there isn't a probationary period. So it just depends on what your job is in the agency. It should absolutely have in your offer letter or any transfer offer letter if you are subject to a probationary period. It says it doesn't sound like federal employees have a lot of recourse as it relates to challenging the executive order. What option does that give someone with 30 plus years? Can we just be let go so easily? Unfortunately, the can we be is yes. Is it legal? No. That's kind of what the fight is here. We definitely have seen people over the last week with decades of bipartisan experience that are not appointees be escorted out with armed guards of the federal government. Your recourse is to file a lawsuit. That is your only recourse. And the law is trying to catch up with this as well. And that's it. That's the recourse. The recourse is absolutely filing a lawsuit or filing with the MSPB. Let's see. Is it possible to share any FAQs of the rights employees have in our situation? So Miriam, somewhat. I think that the facts on this is going to change day to day, agency to agency. And I would be hesitant, I don't know about David, to put some FAQs out based on something that can change tomorrow, based on an injunction being lifted or implemented tomorrow. So that's why it's really important to have these kind of one-on-one conversations or to get your questions answered on webinars like this.
So I will just chime in as well. We're dealing with a number of different agencies, so there's really no claim until there's a final agency decision, and each agency is going to make these decisions based on, the individual circumstances at that agency. So I think it would be, difficult or impossible to, get FAQs that would apply across the board, since we're going to have different justifications from all of these different agencies on why it's necessary to, reduce in their workforce or terminate people.
And so it says, I'm an OPM employee, and they are saying that the email is real, but this is concerning that everyone said it is not. Okay, so let's talk about that. The email is real because it is an email and there are words put on a paper. The question is, are the words that have been put in this electronic document legally binding? Right? So the words that are written are real. They are conveying information to you, and we have no reason to feel that this has not come from the current administration. It is not a phantom email. It is not spam. It is a real email. The question is, the words that are in the email, are those words legally binding? And currently, me and other lawyers, including lawyers who are senators, are saying, hey, it's not, because this isn't how things are done. So I hope that clears things up. Like, we are not saying it's spam, it's phantom. It is just that these words, as they are written, are not legally binding.
Okay, and we're going to take about 10 minutes, and this session is only for 90 minutes. So we're going to take about maybe 10 more minutes of questions before we're going to have to begin to wrap up.
Okay, so let's just, wow. I'm not sure what CR is. It says, what happens if there is
Continuing regulation, continuing resolution.
in the government and their shutdown? I have no idea. The question is,
But what's the question? Because the
question
one
is
is scheduled for March.
what happens is if there is not an extension to CR next month and there is a government shutdown?
Wow, that's a great question. I don't really want to, I don't think we can really speculate on this. It's one of these, kind of unfolding issues. If the government is not in operation, what impact is this going to have on, these offers for folks to resign? That's probably a question that needs to be directed to OPM or to your agency, since there's a very real possibility that there may be a government shutdown if we can't get an agreement, if Congress can't agree in the next, I know it's in March, so.
Another question around the resignation being rescinded. The resignation cannot be rescinded. Once you say you resign, that is it. So do not take a chance on resigning and then saying, oh, I want to have my job back. That's just not going to work. That is something I can say for sure.
And I will add to that, I would not bank on being able to transfer or move into another position as well, because we had that question earlier this week, someone who was placed on administrative leave, but they thought they would be able to move into another position. And the challenge is this information has already been communicated to OPM. So your name is on a list of folks who worked in DEI. I don't think there's any realistic chance that your agency is going to allow you to transition into another position and have to justify to OPM why it did not terminate someone who had worked on DEI.
So maybe you can take this one. I think I know the answer, but if you were hired under a remote announcement on USA Jobs, can you be forced to return to the office?
Well, you've already said this over in terms of whether something can be done. I mean, or, how do you respond if they actually do it? Your contract or your agreement should be binding. Now, it looks like they're going to just blow through these agreements, whether it's with the union or with the individuals, and take their chances on the back end of this. So it should not happen if there's an agreement that you accepted a remote position. They should not, be forcing you to return to work. the alternative is going to be, if they attempt to do that, is, pursuing some type of claim against the agency.
It says, should we join a union if we're not already in one and we're forced on administrative leave? So you have to be eligible for a union. That's one, and not all government workers are union eligible, right? So if you are union eligible, I would say talk to your union rep that is within your department, and yes, see if you can get protections that way. I want
Yeah.
to clarify this, and I want to say that I'm sorry. I am saying return to work. I am a person who works remotely as well, and I work at home, right? And so because I work in the private sector, we say return to work all the time. I am very aware that every federal employee absolutely works. I am a person who works from home as well, and I work very, very hard. So I am not in any way trying to insinuate that people are not working because they're working from home. I'm at home right now and I am working. So please forgive any slippage of the tongue when I say return to work, and I mean return to office. Let's see. What are my rights if the administration tries to abolish my agency via executive order, even if my agency was established by the statute of Congress? You don't have any rights over the agency piece. Congress would have to come in through that. The question is, if your agency, even if it was started by Congress, falls under the executive branch, it is still under the purview of the current president, right? So you would have the rights of everyone else here, even if the agency itself decades ago was established by Congress.
But I will also add that that's where the Administrative Procedure Act is going to come into effect. The agency just can't engage in rulemaking and take action without publishing and providing notice of whatever these changes are and providing a period for comment. And if it does so, then it's going to have to justify that. And a claim will likely be filed in court challenging this action. So, and I would definitely encourage everyone, if a labor union is available to you, definitely join in the labor union. They have pooled resources with the labor unions as well as a lot of the other public interest entities. And I think that's, unless you're, independently wealthy, that's going to be the best option for you to somehow, have some hope of saving your job if action is taken against you and you don't agree with it and you want to challenge it.
Alrighty, I think we're rolling into some different ones. The Civil Service Reform Act does provide protections. The question now is, are the protections being I want to say protected, but that's not the word. What it appears to be is that we have an administration who is coming in saying, because I am the president and this is the executive branch, I can write the rules in the way in which I want them, which seems to be exactly what Elon Musk did when he took over Twitter. It is a very similar thing. However, these are very different entities, right? And there are some that would speculate that our president is not sure how the government works. Thus, he is getting advice from someone from the private sector, right? You still do have rights and protections, which is why lawsuits are available and afforded to you, right? To fight for the protections that were in place. What we have now is someone who is not looking at those as binding on what his decisions are being on a daily basis. David, you want to take that?
No, I don't have anything to add to that. So,
So that's kind of where we are. I will say, as a rule of thumb for employment, I believe in this case, if you do not want to resign, do not resign, and see if you are in fact terminated. Because if you resign, I'm going to give you worst case scenario. Worst case scenario, you resign, you receive a contract, and never receive your money. You are not eligible for unemployment benefits. You will not be eligible to be rehired for the government, because I do believe in that four corners of the document, it is going to say that you agreed to not be rehired by the government because they're trying to trim spending. But if you are terminated, you are eligible for unemployment benefits, which are state specific and not federal. And right. And then you have a better chance at your lawsuit because you were terminated, even though a resignation could be considered constructive termination in certain regards. But right now, that would be my blanketed advice, because there are just too many unknown variables. I have not seen, I don't think David has seen, and I don't know any other lawyer who has seen the actual separation agreement document that has been given to individuals to guarantee that they will be paid throughout the time that they said they will be paid, that your benefits will be kept in place, and all of those things. And honestly, I don't see why there would be any reason to keep that a secret from people before they decide to resign. I have never seen anything like this before. It is just really them asking you to go on trust that they will follow through with all of the things. And you have to think deeply about if you trust this administration to follow through with any of its promises.
I agree with that completely. I definitely have not seen any agreement, and just reiterate, I would not sign or agree to sign anything before I actually see it to be certain that it protects my rights and all benefits as well.
Right. And so the questions that I'm seeing are pretty similar, unless someone else sees something in the chat, I think. Right. Has the EEOC been advised not to take new cases? I have no idea, but I know that the EEOC commissioner has been relieved of her duties.
The EEOC, or at least to my knowledge, has not been advised not to take any additional cases. But you have to understand that the EEOC, at least from the federal standpoint, cases end up at the EEOC after the investigation. There's a 180-day period that the agency has to complete any EEO investigation. And once that's done, there is a report of investigation that's completed. And at that point, the employee can request a hearing before an administrative judge at the EEOC, or the employee can request a final agency decision and then get reviewed by the EEOC Office of Federal Operations, or anytime after 180 days and your complaint has been pending at the agency, you can file a complaint in court. So it's unlikely that the EEOC is going to stop hearing um, public sector cases. I doubt that it will stop hearing private sector cases either. That's unlikely to happen. You have judges, administrative judges, who hear cases at the EEOC, so that's not going to be an issue.
So I guess there's just another email that has come out regarding the fork in the road, but since we've been on this call, so I haven't seen that. Let's see.
Have they shared what it is?
No, they just said it talks about the budget, and if there would be a budget available. Okay, let's see. I guess it's a Q&A that was just received. And the question is, the current funding bill for the federal government expires on March 14th. Will I still receive full pay and benefits if money runs out? The answer is, any government shutdown could potentially affect an employee's pay regardless of whether or not they accept the deferred resignation offer. Moreover, if you accept the deferred resignation offer, you will still be entitled to back pay under the Government Employee Fair Treatment Act of 2019. The next question is, does my agency have VERA for employees who opt to take the deferred resignation offer? The answer, as stated here, is yes. Employees who are eligible for the deferred resignation offer and are at least 50 with at least 20 years of credible federal service, and at any age with at least 25 years are eligible for VERA along with the deferred resignation offer, unless your position is exempt from the deferred resignation program from your agency. So those are two pieces under what was just sent out. I'm trying to just see. I'm scrolling through all of
And
the.
this was sent out by OPM. The Q&A was sent by OPM.
It looks like it was sent out from OPM.
Yeah, that's a little surprising to say that people would be eligible for the VERA as well as the separation package. Um, so that seems to be saying you're entitled to 25,000 plus the 8 months of um, severance.
Yeah, I mean, it definitely sounds shaky. It definitely sounds as though the offer is trying to be incentivized
Yes.
greatly,
I'd
greatly.
like to hear what some of our congressmen or maybe what Senator Kane is going to say about that. How is any of this legal? Um,
So we have, if you were hired as a remote employee, and I know we're going in on time, and never had a physical location to return to, what options would be available? At this point, someone would have to tell you what the physical location is where they expect for you to be at work, right? Like if they're saying return to the office, they have to give you a physical office location, right? Here's a good question. If if the current administration has terminated your protected class or stripped your rights based on, I guess, reclassifying you, can you file suit based on discrimination or something else? I know
okay.
it's gonna be discrimination.
I didn't hear you. What did you say?
The question was if this current administration has terminated or stripped your rights, um, I'm assuming what this person is saying is stripped their rights
Mhm.
under reclassifying them. How can they file based on discrimination or otherwise, like make a legal claim?
Okay. And I heard the question. I didn't hear your comments in response to it. So this, to me, that sounds like a question that probably requires like an individual consultation because there may be some other claims available to you if, for example, the agency issues some type of decision or an explanation of why you're being terminated that impacts like a rule change at the agency? Can they legally do that um, to cause the termination of certain group of employees? Probably not. There may be a constitutional issue as well as whether the agency complied with the Administrative Procedure Act by providing notice and an opportunity to comment before, for example, eliminating a program or eliminating certain functions at the agency. So that probably requires an individual consultation. And it sounds like there are other questions that may require an individual consultation as well. And you can either reach out to our office or other employment attorneys. I know we have folks all over the country who've called in for this webinar. So try to locate an employment attorney wherever you are, whatever jurisdiction you're in. I'm a member of the National Employment Lawyers Association and the Metropolitan Washington Employment Lawyers Association. So these are the NELA is a National Employment Lawyers Association. They are employment lawyers all over the U.S. There's a heavy concentration of employees who specialize in the federal workforce here in Washington, D.C. So this may be the best place to find an employment attorney who specializes in federal employment law. Okay, and I think we're wrapping up. We scheduled this for 90 minutes. Ayesha, do you have any final thoughts or comments? Or I think you're muted.
Yes, I do have a couple of thoughts. This is being recorded. However, it is also being edited. So any place in which I have said a name, we can mute that within the recording. I just am realizing that I said, I believe some first names, hopefully not last names, but even those we can have muted for the recording. Separately, someone said, if you have been fired, what is your recourse now? Hiring a lawyer. And yes, that is your recourse right now. At the very least, you should consult a lawyer to see what your specific remedies could be under this case. I hope that we have been helpful. I know that there are tons of questions. Unfortunately, there were some that we couldn't answer because these executive orders and what is being done by the president is so novel and it's so new and it's so in contravention of what we have been taught as attorneys, right, is the law and is the law of the land. So because of that, it's very difficult to say if this, then that. What we really wanted to make sure that everyone knew was to think about if they want to trust what is being said. Is this coming from a credible source that you feel comfortable will follow through with the commitments that they have made to you here in writing? Also to say that the memo that has been sent out and these Q&As are not legally binding. The only thing that will be legally binding is the actual severance agreement. And that's it for me, David.
Thank you, and I really appreciate it. Thank you so much, Ayesha, and thank you everyone for joining us as well. And I know that it sounds like it's, very challenging, but I just would encourage you, don't lose hope. You would be amazed. Sometimes you just have to, stand in the fight and see things through and not just, send up the white flag. So there are folks who are advocates who are out fighting for justice for you. They're public interest groups, and we expect to see some victories against, these executive orders. So please don't get depressed, or I hope anxiety doesn't, sit in. Some of the things we're going to see over the next week. We'll have, further clarification on how some of the court decisions are going to come down on some of these issues. And particularly as these agencies start to make decisions about trying to reduce their workforce. So once again, definitely you can reach out to our office. I think Kaylin is going to put our contact information in the chat, and or reach out to another employment attorney to get guidance, particularly if you have a personal issue that needs to be addressed on the employment front. All right, thank you, everyone. Everyone have a good week, and we will send out a notice on the next on the next webinar. Shouldn't be too far in the future. Thank you, everyone.